I just never got the sense, nor have I received any information to suggest that Daniel Penny intended to do anything more than to stop Jordan Neely from being a threat.
What did Penny have to gain by killing him? Absolutely nothing.
Even if they showed enough fentanyl to put down an elephant.
This is the In Self-Defense Podcast with Don West, Steve Moses, and Shawn Vincent, exploring high-profile self-defense cases and identifying the lessons learned for concealed carriers.
Hey everybody, I'm Shawn Vincent. Thanks for joining the podcast today. Today we're going to be talking about the Daniel Penny case. That's the case of the New York subway choker. It's been high profile. He was just acquitted this week of negligent homicide. Last week, when the jury couldn't come to a decision, they dropped the charges of second-degree manslaughter. This is an unusual case for us. It's not a firearms case. This was the case of defense of others using less lethal force. That would be an alleged chokehold, a restraint that ended up causing the death of the perceived aggressor. We are big proponents of less lethal use of force as an alternative to your firearm in self-defense cases, but this is a good example that sometimes even less lethal force can still be lethal force, and there's some important considerations in this case for armed defenders, concealed carriers, or anyone concerned with self-defense. Otherwise, we'll be joined by Don West. He's National Trial Counsel for CCW SAFE and a veteran criminal defense attorney. We're going to talk about this interesting verdict and jury deliberations, plus some of the legal nuances that contributed to the defense of this case. We're also going to be talking to Steve Moses. He's a self-defense instructor. He's had experience training in chokeholds. He's going to give us his insights. As always, when we do these podcasts, we're not giving specific legal advice. We're not giving specific tactical advice. What this is an informed conversation about the lessons learned for defenders from high-profile self-defense cases. We're glad you're here. Here's my conversation with Don West and Steve Moses about the Daniel Penny case. Anybody who's interested in self-defense has caught this national story. It's the acquittal of 26-year-old Daniel Penny, a Marine veteran who, an architecture student who, leaving class and going to the gym in Manhattan back on May 1st of 2023, boarded the subway, encountered a man named Jordan Neely, 30 years old. He's got a history of homelessness, history of mental illness, a history of drug abuse. And from what we know is that Neely was having a fit on the train. He came into this car, he threw his jacket down, and he basically started saying that he was hungry and that he wanted to go back to jail, and started, if not threatening people, then acting in a very threatening manner, especially with this idea that he indicated he wanted to go back to jail. And on this train, here's Penny. He thinks that he can do something to help all the other bystanders that are on this car. We know that they called 9 people who are on the train to the trial in this, so we know there are several there, and so he gets Neely in this chokehold. Essentially, he takes him to the ground, and I haven't been able to find the whole video. Did either of you see the whole video of this, or just bits that they put in the news?
I've seen bits and pieces of it from different perspectives, but
not the whole thing in continuity. No, I had that same problem too. But what it seems like is that he brings him down to the ground, and Penny's underneath him, and he's got his arm around his neck, and then soon there's a couple other guys around trying to hold down Neely's arms. Neely resisting and trying to get out of the hole, but not as aggressively as I've seen it done in other cases that I've been involved. After about 3 minutes, the subway comes to a stop. Most of the passengers get out. A lot of this is recorded on two different bystanders' cell phones. Um, and in the end, it's almost 6 minutes that Penny had Neely in this hold, and ultimately Neely expires. He dies. And Penny's arrested. They charge him, Don, and I think this is not a bad place to start. They charge him with second degree manslaughter with a second count of what is it, criminally negligent homicide.
Well, to the specific charges in this case, I think you can look at the, we'll call it the top count and the lesser count as indeed a lesser included offense of the more serious charge of second degree manslaughter. I will, in fact, grab a note that I found that specifically says this about the manslaughter charge. It requires proving that a defendant recklessly caused another person's death. The standard entails, among other things, consciously disregarding a substantial and unjustifiable risk that an action will be deadly. So that's got a higher level of knowledge and intent and purpose, that you know what you're doing is really dangerous, and that you are, in a sense, disregarding that risk to continue to do what you started, and that it ultimately results in death. So that was the manslaughter charge. I don't think we can talk about first degree, second degree in levels of homicide, because every place, every jurisdiction calls it something else typically.
Different.
So we'll call this one the reckless manslaughter. I think that's the fair description for it. And then the second charge was characterized as criminally negligent homicide. We know that homicide does not connote criminal activity or not. It just means that someone died at the hands of another. So criminally negligent homicide, as opposed to the level of recklessness and disregarding a substantial and unjustifiable risk that an action will be deadly, is more defined as engaging in what is described as blameworthy conduct, but not perceiving the risk that your conduct is causing. So that's why it's lesser, a different kind of mental state, a lower level of negligence, recklessness, in a sense, disregard for the consequences of your conduct. It's a little tricky. It's almost, I think for the jury, it was a very difficult instruction to sort out and figure out clearly what one meant and what the other didn't in some ways.
They asked for clarification during deliberation for both those terms, negligence and reckless.
Yeah, they're tricky concepts.
But I think right off the bat, this is not a murder charge. It's not a first-degree murder charge. It's not a second-degree murder charge. I think a lot of that has to do with the fact that, unlike most of the cases we talk about, this was not a firearms case.
Agreed. Yeah,
he wasn't armed. And Steve, we talk all the time about how one of the tools in an armed defender's toolbox is less lethal options, which would include physical contact.
Yes, sir.
And so, just tell me a little bit from someone who is trained in Brazilian Jiu-Jitsu and also an expert in training folks in firearms, where he is on this use of force continuum in this case.
Well, I would just say that's fairly close to soft hands. He's not striking him. He's not doing anything overtly that should cause serious bodily injury or death. I think it's maybe one step up from using OC or presence or words and using lethal force. So I think it's a very good use of defensive techniques, assuming, of course, that you know what you're doing and you apply them properly and you pay attention to what's going on while you're actually involved in such an action.
Well, and we're very careful with the term we use. We use less lethal force on purpose because just because it's not a firearm doesn't mean it can't be lethal. And there's always that possibility of using too much force.
Right. For a long time, you'd heard the term less than lethal. And
Mm-hmm.
finally, a lot of organizations, and I'm one of those persons, the verbiage I use now is less lethal.
Don, I want to quote you something from one of the articles that I read on this case. And as we discussed this, we weren't in the courtroom, and you and I know that the jury's the only folks who see only what the judge has allowed to be seen, and everything that the judge is allowed to be seen. So they're the only ones that have the full picture of the case, especially without the things that were excluded that maybe the parties of the case and the public might know if they are in the courtroom. But prosecutors acknowledged during trial that there was a reason to fear Mr. Neely, and they said even cause for Mr. Penny to intervene. But they said that the former Marine went too far when he held on to Mr. Neely's neck for 6 minutes. And in a lot of ways, the public controversy over this case is whether Penny is acting like a vigilante, or the other side of that is that he was this good Samaritan who stepped up when nobody would. That's certainly the defense's narrative, and that he was a protector and defending the lives of the other people on this train. And in a lot of ways, that's not nearly as important to the criminal trial as the question, did he apply that chokehold for longer than was necessary? Do you think that's right?
I've struggled with how the prosecution was framing this all along, because you're right. They sort of conceded early on that it wasn't unreasonable for Daniel Penny to insert himself in this, that the subway riders had reason to be concerned. Certainly, Neely was saying things that would be very concerning and were literally threatening. And then part of their sort of assessment would be, how much of this did he mean, and was he about to act on it? It's certainly, people can view it somewhat differently, but there's a consensus of people, including the prosecutor ultimately, that took him seriously enough that they thought intervening to some degree was reasonable and appropriate. So then now you've got the use of force to be appropriate. Now the question then becomes, where does that transition either into disproportionate force, too much force for the circumstances, or disproportionate? I think the way it's being characterized in this case is just too long. It wasn't disproportionate maybe to do what he did for the first minute or two or three, but is there a point in time where it's disproportionate and therefore becomes sort of a criminal recklessness, even the lesser charge of criminal negligence, where Penny knew what he was doing was dangerous. He knew it was likely to, in fact, even be life-threatening, and that he continued to do it anyway, even when there was no legal justification for it. I think the whole thing was pretty murky right from the beginning, and in some ways, this was the kind of cases, how does it strike you? What do you think in that situation? And that may be as different as the angle that you had as you were watching this unfold, or your frame of mind and frame of reference when you started viewing the trial or listening to it and kind of assessing things along the way. I don't think that I've done much to answer your question or even to offer much insight.
Other than to say that it's murky.
Yeah,
right?
yeah.
But Steve, 6 minutes is a long time to have
6
someone
minutes
in a
is a
hold, isn't
long
it?
time. And I would go so far as to say that if he had applied that choke correctly, or in a manner in which he meant to induce unconsciousness and left that on for 6 minutes, I think there's a very good reason that Mr. Neely would have been seriously injured or even died. However, when I look at the pictures, it appears to me that that restraint or that version of a rear naked choke looks to me like it's applied relatively loosely. He has his strong hand, it looks like on top of Neely's head. It doesn't look like he's buried his left hand, the one that's going around Mr. Neely's neck, on his other bicep. And to that end, it just does not look like he's somebody that's being basically what we would say choked out, where they, become unconscious. You release the choke, and typically they recover very quickly. I've seen it happen. I've choked out a couple of guys. This was all during training, and of course, it's kind of spooky for a moment while you're, picking their legs up and getting blood back down to their head before they pick back up. But this is something that is not only very common. There are people in Brazilian Jiu-Jitsu gyms and judo dojos right now that are practicing these techniques on each other, probably right now all over the United States, probably all over the world.
Well, to my point, Steve, I guess what I didn't say that I was sort of alluding to is I don't know that he was in a chokehold, a real chokehold at all, rather than Penny's real intent was just to restrain him. I know he had some background in the chokehold techniques, but at the same time, I don't know what he was really trying to do.
So kind of a distinction where he had him on top of him and he had his arm around his chest and neck, and if Neely was trying to get away more, he could tighten it, and that might be a hold at that point, but he could loosen it if he wanted to. And I'll read
holding them loosely to me.
Yeah, so someone who came to testify at trial was somebody who trained Penny in the Marine Corps on chokeholds. His name was Joseph Kaballer, and he testified that he watched the videos and suggested that Penny might have put his training into practice improperly. Steve, he distinguished between how they're trained for an air choke and a blood choke. And he says at times it appeared that Mr. Penny was not applying a lot of pressure. So that's to your point, Don, that he was sort of holding them and then moving pressure on and off. Steve, do you want to comment on the blood choke and air choke?
Well, to me, in the pictures that I have, and I've got a series of pictures here, one includes a number of shots in where it appears that Neely's arm is actually moving around. It appears to me that that's a blood choke. The reason I say that is Jordan Neely's chin is aligned with the crook in Penny's arm. So it appears that the head is right here, and he's got pressure on the right carotid and the ability to apply pressure on the left carotid without having an air choke. An air choke is very painful. We all know it's very dangerous. We don't use these typically when we're training just because they are, or if you do, you release it. Being in one is extremely painful, and I would think that if he had, since I see Mr. Neely's arm moving around, I would think if he had him in an air choke, you would see much more vigorous resistance from Neely than what I'm seeing. All the
because an air choke is they're actually blocking your airway and you can't breathe.
Imagine just a bar, just basically crushing your trachea.
Whereas a blood choke's designed to cut the blood flow up to your brain so you pass out, right. But then you can let go, the blood goes back, and you wake back up is the idea.
Yes, if you don't hold it on too long.
Yeah.
But Steve, though, as a practical matter, if someone successfully applied a blood choke, isn't their choking victim going to be unconscious?
You can choke them unconscious if that's your intent. I think in the pictures that I'm seeing, I'm not saying that's not doable. I've choked out a guy with just one arm before, but it looks to me like it'd be relatively difficult for him to apply it, kind of using his hands where they are. I'm not saying it's impossible, but typically what happens is when you do, they go to sleep.
So you don't need to keep applying pressure at that point to restrain them. Exactly.
You do not want to. You can literally just lighten up, make sure you got that. And that makes me wonder if maybe he applied the choke and then he just kind of moved over here just because I'm restraining him. And perhaps he was going to come back in, hide the hand, and do it again. I can't tell. All I know is from these pictures is that does not look like that's a properly applied tight rear naked choke to me.
I just never got the sense, nor have I received any information to suggest that Daniel Penny intended to do anything more than to stop Jordan Neely from being a threat. He wasn't necessarily trying to put him out or keep him out or render him unconscious in any way. He just wanted to hold on to him until the police got there.
Well, and he said that with his own words to investigators after it. He said, I wasn't trying to injure him. I was just trying to keep him from hurting someone else. He was threatening people, and that's what we learned in the Marines.
Well, I might add, though, he may have, or his intent may have been to go ahead and apply enough pressure from that rear naked choke to gain control of Neely. And then, okay, I've got it. And then he relaxed his arms. And again, I'm just basing this on the pictures that I've seen.
So in these muddy waters that we're in, so however proficiently or improficiently he applied whatever choke or restraint that he was attempting, uh, on one of the videos, there's the voice of a woman who says he's dying, and you've got to let him go. There's another guy, Eric uh, Gonzalez, who is known for a long time as the man in the black hat, who said he tried to get Penny's attention and told him that he would hold Mr. Neely's arm so he could adjust his hold. He said, I'm going to grab his hand so you can let go. And then there's this other testimony from a Mr. Goodson who said, if you don't let him go and that's the state his body is in, you're going to lose him. Um, one of these witnesses was criticized for evolving their testimony between their grand jury testimony and the trial testimony, and that came out during trial. But there's at least 3 accounts of bystanders who had a different perspective on whether Neely was actually restrained and whether it was necessary for Penny to keep going. What's your take on that, Don?
I don't know. I don't know how you factor all of that in because there's both the subjective and objective aspects of self defense. I take it that Penny, from a subjective standpoint, thought he was doing the right thing and the necessary thing.
Yeah.
But of course, that's only the first part of the test. It also has to pass an objective test. And that's the one that perhaps witnesses will offer some insight into, or ultimately the jury, as to whether what he did was objectively reasonable under the circumstances. And that's where you get the conflicts in the evidence and the contradictions there that would raise that issue. But like I said, I never thought Penny intended to kill Jordan Neely or even intended to keep him unconscious. He just intended to restrain him. At, at the same time, I don't know how he would factor in what the other passengers were saying, the other witnesses were saying, as to how he thought it was necessary to modify his own conduct.
Steve, if you've done that kind of training and you've got somebody in a stressful circumstance and you're trying to restrain them and they're on top of you, how good are your listening skills and your comprehension skills at that point?
Right now, I'm pretty much focusing on the task at hand, which I've got to control this guy. From what I understand, he was agitated and he was combative. He's probably a fairly strong individual. And the other thing I might add is that probably there's very few people that were on that subway at that time that really maybe knew what was taking place. And the fact that perhaps Neely was starting to stop resisting, closing his eyes, may very well have suggested to someone else who doesn't have any knowledge about how any of this works that he might be in danger of dying.
One bystander said that Penny seemed to be sort of in a trance at that point, because he's engaged in this melee, and I guess I suspect, Don, that jurors might understand that if you're in that circumstance, you got this guy on top of you, and other, you might not be as alert as the witnesses were.
That certainly makes sense. And when I said murky on some of the legal issues, I think some of the factual stuff is equally murky as it applies to the legal stuff. And that is, was there ever legal justification to use deadly force? Was Jordan Neely ever a deadly force threat, notwithstanding his claim that he would kill everybody or go back to prison? What did his threats rise to the level of justifying deadly force, or was that a very dynamic move aspect of this in and of itself? And
Well, I mean,
and
so that's
ultimately,
interesting.
well, how much force did Daniel Penny use? Did he ever use deadly force, notwithstanding the fact that ultimately Jordan Neely died? It's
So that's a big question then, and so that kind of leads us into this battle of the doctors that were very important witnesses in this case, right? And so the medical examiner that testified on behalf of the state, her name was Dr. Cynthia Harris. She determined that Neely died from compression of the neck. Uh, you talked a little bit about the flailing and the arms twitching and things, Steve. She said that Mr. Neely's flailing legs and spasms were involuntary movements. They indicated brain damage from a lack of oxygen and what she called air hunger. Um, she testified that the autopsy reports and the video shot by bystanders and investigative reports provided all she needed to know to reach her conclusion. And Don, here's a bit of testimony that really stood out to me. And the prosecutors had to have been wincing when they heard her say this, because there is some critical I'm going to suspect on cross-examination by the defense about why she didn't do a toxicology report. And she insists that, and this is the quote, no toxicological result imaginable was going to change my opinion, even if they showed enough fentanyl to put down an elephant. So she was, for 3 days of testimony, she stuck to her guns that it was compression of the neck, and that she put that together by the autopsy report, the videos, and the investigative reports that she was provided.
Yeah, the cross-examination can be considerably shortened when an expert takes that kind of position. They expose their own bias and or ignorance, maybe both, at that point, and then that, in my mind, makes it sort of ripe for a contrary opinion by another expert. Both experts are considered experts. They were both allowed to testify as experts.
Qualified.
And qualified in the sense that they passed that fairly low bar, but nonetheless they were allowed to testify, and yet their opinions were diametrically opposed, which
Sure.
In some respects is even more confusing and not very helpful to the jury trying to resolve a very important aspect of the case.
So the diametrically opposite opinion was a pathologist called Dr. Satish Chandru. I probably got his name wrong, but forgive me, doctor. And he said he cited medical records, and he testified that the location and the extent of the bruising, along with other records, led him to conclude that the chokehold was not fatal. And what he claimed was that there was this combined effects of sickle cell crisis, the schizophrenia, both of which it turned out Neely suffered from, the struggle and the restraint, and the presence of the synthetic marijuana. Those combined effects are what caused Neely's death.
Mm-hmm. Mm-hmm.
And then I got to say, I think that when you add that to the fact that the medical examiner basically said, even if he had a lethal dose of drugs in him, I don't think that's what killed him.
It's a shame this case got once again so politicized that it appears that some of the experts had to stake a claim and stick with it no matter what. That kind of opinion by an expert is completely useless other than to undermine their own credibility.
Right.
This is somewhat reminiscent, I think, of some of the forensic issues in the George Floyd case, or it was a question of neck compression, that was
Mhm.
a straight line for the prosecution, saying that's why he died. It was the neck compression. And yet there were all sorts of toxicology issues and other health related issues.
It's sort of disingenuous of them to completely discredit other health factors and drug factors and be so staunchly certain that it was just the the choke that did it and that the other things wouldn't have contributed. And I guess here's why that's important, because what led us into this line of discussion was that when we go back to the charges, it's important whether Penny actually thought he was applying deadly force or not. And if he didn't know or couldn't have known that Neely suffered from sickle cell anemia, they don't even know if Neely knew he suffered from sickle cell anemia, or that the drugs were a factor, or I don't know what schizophrenia has to do with any of it. But if there's enough, I think that if you're the defense in this and you throw in enough doubt about how fragile he was, the more you have that on your side, the less certain the jury is that Penny should have known that what he was doing was going to kill this guy, right?
Yeah, that's the thing in cases like this when you're trying to assess the amount of force, disproportional force, whether it's deadly force or not. It's almost that the fact that Jordan Neely died means that it was the use of deadly force, or at least disproportional force, that resulted in death. And if there's no direct causation between what Daniel Penny did and Jordan Neely's death, or if there's some significant issue surrounding that, then that, I think, has a significant impact on whether his conduct was criminal or not. And that's, of course, the only thing that the jury's trying to decide, is
Yeah.
whether or not he committed a crime, which doesn't even answer the question, because, of course, he committed a crime by choking somebody in the middle of a subway car, except he claimed he was justified. Remember the process, right? The prosecutor still has to prove that the crime was committed and that the person on trial is the person that committed it. And
Yeah.
then once there's a self-defense claim asserted, the prosecution has the additional burden of disproving self-defense beyond a reasonable doubt. And in fact, that gets so convoluted in cases like this, especially when there's alternate causation theories, that it's mind-blowing that a jury can keep it straight at all. I think that aspect of this case was even further compounded the way the case was presented to the jury. I guess you call it in a procedural way. If you recall, when they were sent out to deliberate, they were directed to only address count one, the manslaughter count.
Yeah,
right?
yeah.
And only after they reached a verdict on the manslaughter count were they supposed to consider the criminally negligent homicide count. And in fact, in the jury instructions, it got so wild and I think almost impossible to follow. I made a copy of some of that language. I want to just point out.
Yeah, please.
So this is the instruction to the jury on the issue of manslaughter in the second degree. If you find the defendant guilty of count one, manslaughter in the second degree, then do not consider and do not render a verdict on count two, criminally negligent homicide. If you find the defendant not guilty of count one, manslaughter in the second degree, for the reason that the people, meaning the state, the prosecutors, have failed to prove beyond a reasonable doubt that the defendant was not justified, that's the self-defense aspect of it,
Yeah.
then you must not consider count two, criminally negligent homicide, and you must also find the defendant not guilty of that count. That's a kind of a fancy, difficult to understand way of saying that self-defense applies to both counts.
Right.
So if you acquit him of the count one manslaughter on self-defense, then he has to be acquitted on count two because self-defense applies to both. On the other hand, it says if you find the defendant not guilty of count one manslaughter in the second degree for some reason other than the lack of justification, then proceed to consider and render a verdict on count two, criminally negligent homicide. So that tells me that the jury had to figure out whether he was not guilty or guilty of count one, and also whether or not the defense of justification applied, and only if they found him not guilty of count one for some reason other than self-defense did they go to count two.
They had the disadvantage of not being able to hire a lawyer to come back there and explain that to them.
Oh my goodness, yeah. Well, one last thing. Let me put the I or the dot on the I. How challenging I thought this process was. In my experience, that typically lesser included offenses that go to the jury are alternative verdicts as the jury works from the top count down. And that's internal stuff. That's not with the judge's involvement. And they're essentially told that you take a look at the first count, call it first degree murder. And if you unanimously decide guilty or not guilty, then render the verdict. But if you can't unanimously decide that count, then move to the next lesser included count and keep going until you find one for which you are unanimous. Well, that's not what the jury was allowed to do in this case. They tried to get a unanimous verdict on count one, the manslaughter count, and never ever reached it. So that was an impasse. And the judge was they gave him the Allen charge, the so-called dynamite charge, which is where the judge essentially guilts the jury into keep going.
We've been here for 7 weeks. We saw 40 witnesses.
Exactly.
Go back and try harder. This is very expensive.
Nobody will do better than you, put your heads together and basically get a verdict. Okay. That didn't work. So they're now at this point where they can't reach unanimous verdict on count one. So what do? Well, the judge would have to declare a mistrial because of somehow the way that this thing was going to the jury. They couldn't get past count one to count two if they were hung.
Right.
So keeping in mind that the prosecutor essentially has all the cards on what to charge and when to charge it. So it was the prosecutor's motion to the judge, we want to dismiss count one.
Okay, so they knew a mistrial for the defense is almost as good as an acquittal. It's certainly way better than a conviction because that means they have to decide if they want to try it again and we go through it, but we're not going to jail. So the prosecutor's like, hold, we're about to mistry this case. Let's see if we can get the negligent homicide to stick. And we're going to voluntarily give up the first charge.
So I think they voluntarily gave up the first charge by dismissed it, and they voluntarily gave it up forever. They could have forced a mistrial and tried it again. If they were supremely confident in their case and they thought there was some irregularity the way the evidence came out or a rogue juror that was hanging this thing up, they could have allowed the mistrial to take place, I suspect, and then tried it again. But they gave that.
The judge dismisses the charge, it's dismissed, and there's no
I think clearly jeopardy has attached at that point, double jeopardy issues. So then they forego that, and it moves on, allowing the jury to render a verdict on count two. Yeah. I'm speculating here. It's unfortunate this case wasn't on television. I would have loved to have watched this case from the beginning to end. But I think I'm guessing the prosecutor probably felt pretty confident if they hung up on count one. They had at least a few people that were finding Penny guilty of the main charge, the reckless behavior manslaughter.
You got a pretty good shot at the lesser charge, is what they were thinking.
Yeah.
Let me read you what the judge said. News Nation reported this.
Okay.
Here's what the judge said. What I'm going to do is this. Manslaughter in the second degree is dismissed. You are now free to consider count two. He's talking to the jury here. Whether that makes any difference, I have no idea. The judge is surprised, I think, that they came back and were able to come up with an acquittal on the second charge also. He says, but I now direct you to focus on deliberations of count two and render a verdict on that one. And yeah, I agree with you, Don. If I'm the defense, I'm a little nervous that weekend because I'm thinking that they've got a couple people who maybe we only have a couple holdouts for
Mm-hmm.
acquittal, and this is going to do it. But I think what happened is they went home for the weekend, and they came back on Monday morning, and Monday they were able to decide. Somebody changed their mind and said, "You know what? Let's just acquit it and get out of here."
Yeah, they were out, what, 3 days or more?
A Thursday and a
Deliber-
Friday.
yeah, deliberating the manslaughter count before it got dismissed, and proportionate deliberations were a fraction, just a few hours, right? And they came back with a unanimous. Keeping in mind the verdict is unanimous, so it was all 12 people voted for not guilty.
Yeah, if somebody had an experience over the weekend, I think that they had time to think about it. They probably watched news against the direction of the court, or talked to somebody, or just had. We'll give them the benefit of the doubt. Just had time for quiet contemplation and didn't feel like spending another week in court in this high profile thing, and went ahead and uh, went with the majority. Steve, on this point, there's a book I really like that I think is great for trial lawyers of all types. It's called Thinking Fast and Slow by Dr. Danny Kahneman. He just passed away this year, and he made a whole career on this idea of prospect theory and making decisions when there are consequences, right? And there's uncertainty, and that's textbook for Don. What we ask a jury to do, especially in these self-defense cases, we're asking them often to peer into the mind and the heart of a defender and decide whether they acted honestly and in good faith and in sincere fear of great bodily harm or death to themselves or somebody else, right? So it's unknowable, but we have to make a decision that's going to affect this person's entire life. And what Kahneman says is that when we're given a choice that is too complicated or too much work, we often subconsciously substitute another problem and solve that one instead, right? And so when you were describing just how convoluted the jury instructions were, Steve, I'm going to go back. You'd asked if one woman had a baby that she was trying to protect, and I read that as well. Like she brought this baby in close and moved away. There's this 19-year-old high school girl on the subway, young woman, and she said that she was very nervous when he came on the train and couldn't wait for the train to stop. And she's the one who stepped out and recorded a lot of what happened. There is even that guy Juan Vasquez, the 59-year-old reporter from Mexico, said that this is not a normal thing to happen on a subway, and that he was acting threatening. This woman named Shadrin Shrunk, I apologize if I mispronounced your name. She said she was filled with a sense of relief when Penny took Mr. Neely to the ground. It was the first time in my life, she said, where I took a moment because I thought I was going to die. That 19-year-old said how relieved she was when he said he was the only one who stepped up. So, did he mean to apply deadly force? Did he not mean to apply deadly force? I think most people believe he did not mean to kill him. I don't think anyone on that jury really thought he intended to end this guy's life. At least half the people on that car seemed relieved that somebody stepped in to restrain this guy because they were legitimately afraid of him. And whatever that legalese is, I feel like folks just said, we're not going to convict this guy for that act, even if he didn't do it exactly right. And can't you hear like some of the folks that you've trained, Steve, if one of them was on that jury and they're like, this guy was acting crazy and maybe he didn't do everything right, but I'm not sending a Marine veteran with no criminal past to jail for manslaughter or homicide for risking himself to step up and take this guy down and try to restrain him?
Well, I just keep asking myself, what did Penny have to gain by killing him? Absolutely nothing. He was a Marine. He was able to follow orders. He knew the consequences of his actions. There was no win in this for Penny to kill this guy. He basically, in my opinion, did what he thought was the right thing. And fortunately, it appears the jury thought the same.
And Don, they offered character witness on behalf of Mr. Penny in this case, which doesn't happen in every case. We've talked about a whole bunch of cases where the defense has to fight real hard to try to get motions in limine on social media posts or previous bad acts that would have no relevance really on the case, but only would serve to prejudice the jury against them for being a bad guy. And often with a savvy defense lawyer, you can keep that stuff out or drastically limit it. But if you know that stuff exists, you're not going to go to the jury and tell them what a great guy your defendant is, or bring up their mom to talk about what a sweet boy he is, or his old drill instructor to say what an upstanding citizen he was, because that opens the door for the prosecution to bypass all that motion and limine stuff and try to impeach your characterization of the guy's character.
Yeah, that's exactly right. In fact, that's the term that lawyers and judges use when someone has effectively done something that allows evidence that was previously excluded in, or establishes a situation where the judge reevaluates the admissibility of evidence. And they call that opening the door. For example, you can't ask about certain criminal arrests that didn't result in convictions, or the details of certain things, unless you open the door. And you can't necessarily introduce certain character traits unless you do something that creates an opportunity that didn't otherwise exist. And of course, that's one of the very reasons I think why some people choose, when I say some people, I guess I'm talking about defense lawyers, often will discourage their client from taking the stand, even if they're not concerned about the testimony being unbelievable, or that there's problems in a typical witness cross-examination, but because certain situations only occur if the person is on the stand and can be cross-examined about stuff. So there's a lot of strategy.
The defendant himself could accidentally open the door
Sure.
for the prosecution to bring in stuff that his lawyer's been trying to keep out.
Well, criminal convictions would be one, for example. An admissible criminal felony that wouldn't otherwise be known by the jury would be fair game on credibility if the person took the stand. Sure.
So, notwithstanding, they chose not to have Penny testify in this case. So they chose not to have Penny testify in this case. I think it's because they had some good video statements from his interviews after the incident with police, where he was able to, make that claim that he wasn't trying to hurt him. He was just trying to restrain him. And that's to keep him from hurting somebody else. And one bit that came out in one of the articles I read, a lot of the media were quoting how the guy said he didn't care if he went to jail, but what Penny said to the police officers, let's see if I can get it, was, that he said, I'm going to kill everybody. I'm going to go to prison forever. I don't care. I'm going to do this. So if that's true, or that's what Penny legitimately interpreted this guy as saying, then that goes to the fact that he thought this guy was on purpose going to murder somebody so he could go to jail for the rest of his life and presumptively have care and be fed.
I wish, as we said before, I wish the case had been televised. I wish I understood more about the strategy of him not testifying. And I also wish, I'm assuming that the statements that you're referring to, his interview with the police, was admitted into evidence,
Mhm.
and the jury had the benefit of listening to it and
It
evaluating
was
it.
reported. I can't guarantee that it was presented.
But
Uh,
it would have been something presented by the prosecutor, and that's a pretty difficult decision by the prosecutor as to whether to introduce what is, in a sense, an exculpatory statement. We know it happens all the time because the prosecutor either has a different something else in mind they can do with it, but they introduce the idea before the jury of self-defense, and the defendant essentially is relieved from having to testify because there's his statement in the record. Now, this is one of those situations where there were lots of other witnesses, so there was evidence of self-defense. Whether Penny ever issued a statement of any sort or uttered a word to anybody, there were lots
to,
of
to the point
independent
where
witnesses.
the prosecution basically concedes it
Yeah,
in their opening statements
yeah,
that that's the
yeah.
case.
So whatever mileage they thought they could get out of the statement, I guess there's the thinking behind that. In a completely different context, of course, there may have been no choice but for Daniel Penny to take the stand and testify if there weren't witnesses or that could help him in his self-defense claim, or if there was an inconsistency or a contradiction that he had to get on the stand to explain.
To explain.
Yeah.
Yeah. So I'm curious, Steve, as we're wrapping this up, what were your thoughts about the verdict? Did it surprise you at all? Did it not surprise you? And what do you think some of the lessons are for our folks?
The verdict did not surprise me. I was a little bit, unhappy that it ever even occurred that he was charged. And some of the things that were saying, I found those kind of distressing. But I was optimistic that, that he would prevail and pleased that he would. In terms of concealed carriers or persons operating on behalf of others in terms of third party defense, you have to be so careful about what you do because we can see an instance here where somebody really did pretty much everything, up and up and correct, and still had to pay the price for doing that, with consequences would have been horrible. So, my recommendation is do not get involved in situations like this with the understanding that there may be an exception that it so shocks the conscience that you feel like you have to do that. That might be someone that was assaulting a child or something to that effect. That, okay, I will go ahead and I will get involved, but I'm going to do the very best that I can to try to de escalate this situation. This would have been a great time to have OC. Makes me wish that we probably ought to have Chuck Haggard back on again because
Mm-hmm.
this
Yeah.
probably could have, de-escalated that situation very quickly. And so,
Well, yeah. So to that point, he did an interview yesterday with Fox News where he expressed that to let the guy go, now he's in this prone position, meaning Daniel Penny is on his prone position on his back. And if you let the other guy go, now he's potentially got a real problem again. He's in a vulnerable position. And I think, Steve, that's from a tactical point of view. If you're going to grapple with somebody and restrain them, you have to worry about how you're going to get untangled from that guy, right?
well, that, and you also have to worry about while you have your hands tied up, is there someone that may mistake what's going on and view you as an assailant, or just make an attempt to defend, the other person. And it's very easy to, have somebody come up there and just kick you right in the head, and stuff like that happens all the time. The value in Brazilian Jiu Jitsu, in many ways, is that if I do have to defend myself, I can probably do that without striking somebody. I can put somebody to sleep. I can take them out. I have all these other options. But in terms of going to the ground, while there may be a few instances while going to the ground is the proper thing to do, that's something we want to avoid. And going to the ground with someone else basically puts us in a very, very risky position. And I don't recommend it. It's just that's what I'm going to do in order to control this guy.
Don, kind of how'd you take the verdict and what do you think it says about how justice was rendered in this case?
I was a little surprised that there was a verdict. I thought that with no unanimity on the manslaughter count, that the criminally negligent homicide may have the same fate, depending on what they were hung up on. I didn't see how just them considering the second count would resolve some of their disagreements if they were arguing over the facts or even arguing over some of the medical legal issues. So two things: one, they got a verdict, and secondly, they got it quickly. Meant that maybe what you said is in fact what happened. They were done with it at that point. Maybe somebody had a realization, an insight, a reinterpretation of the significance of some testimony when they had some quiet time over the weekend. Who knows what may have shifted that? And I do hope there will be a point in time where one or more of the jurors have a serious sort of debrief conversation. I think that would be helpful to a lot of people to understand what their thinking was. But of course, unfortunately, they'll be targeted no matter what their position is and no matter what their explanation
Sure, it's
is.
recharged.
If they go public, it's going to be horrible for them. You and I have been through that, seeing jurors that have been viciously attacked and such. So I was a little surprised that they got a verdict, a little even more surprised that it was so quick, but relieved in a sense. I thought that was the right verdict based upon the information that I had. There's no appeal, by the way, in case somebody's wondering. They dismissed count one with the prosecution's at the prosecution's request. Count two, the negligent homicide, was an acquittal. So there's no appeal available to the prosecutor to revisit this. There is a pending civil suit. I thought that was an interesting tactic that Jordan Neely's family sued Daniel Penny civilly, even while this case was in
Right
trial.
at the end of the trial. Yeah. That could be a whole nother conversation, but that means that his legal woes are not over and that he's to spend more money in that defense. Don, let me ask you this as we kind of wrap up. Considering how convoluted and strange all the charges were, do you think that somewhere that there's a little bit of a jury nullification in all of this? That maybe because no one's going to, I don't think they polled them. We won't know, did they decide that he was justified in using the deadly force, or just that they don't know that he meant to use deadly force? Or I think my read is I'll bet most of those jurors believe that he was justified in trying to protect those other riders from this guy. He was justified in using force. He didn't think he was using deadly force, and he either accidentally used too much or there are contributing circumstances that caused a horrible thing to happen. But regardless of that, they're just not going to put this guy in jail for that thing.
It was interesting to me. The prosecutor was criticized during the trial for making comments about, while he faced 15 years on count one and 4 years on count two, none of it was mandatory. And the reason they were criticized for that is because it was sort of suggesting that, yeah, go ahead and convict him, and then the judge won't have to send him to prison. There might be a point in time where the jury, after they got count one resolved, looked at count two and said, wait a second, if he's convicted and we don't think he should go to prison, we think that at the worst, it was an unintended consequence of someone who, in many respects, was characterized as a good Samaritan. And it's just not right. That has a lot to do with our criminal justice system. Is it right? Yeah. Would it be fair? And that they may simply have not been willing to surrender control over Daniel Penny's fate to the judge and just not expose him to the risk of 4 years in prison. And they may very well have done what you said. There a type of nullification or a recognition that of all of the horrible, vicious, cruel things people do and deserve to be punished for, this was awful, but not one that should be criminally prosecuted.
I saw you nod, and Steve, do you have anything to add to that, or?
No, no, no. I mean, again, I'm just, pleased with the outcome. And again, just, as a caution to concealed carriers, CCW safe members, this is not something you want to take on lightly. And I think, unfortunately, Mr. Penny showed that that's why that is indeed the case.
All right, everybody, that's the podcast for today. I really appreciate you listening through to the end. I've got a whole bunch more interesting cases in the hopper. We'll be releasing those over the next several weeks. I hope you join us. Until then, as always, be smart, stay safe, and take care.
I've choked out a guy with just one arm before.